Yeah, okay, I'll sit
I'm going to give Dr. David Clark a call.
Oh, thank you, Mr. Chair. I have been waiting for a while. So I appreciate the call. Sir, this part of the Act, of course, tidies things up, as my colleague Stuart Nash has pointed to, and I want to speak specifically to Clause 71 and the subsection 1C, which relates to when there is no requirement for the normal procedures to apply in respect of diligence in terms of anti-money laundering. And I'll read it out for those who are following this outside of the House. Subsection 1 does not apply to a person for whom a reporting entity under the Anti-Money Laundering and Countering Financing of Terrorism Act 2009 has conducted the consumer due diligence procedures required for customer due diligence under that Act and regulations made under that Act. So this is an exemption we're talking about in the law for people who have already complied with anti-money laundering and countering financing of terrorism procedures. And we would understand that often these kinds of exemptions are in place to avoid duplication. That is why these kinds of exemptions are in the law. I raised this in an earlier stage of the bill, and I want to raise it here again because, again, we have a similar instance where we have a piece of law in place designed to make sure that there is not duplication of a service. And I would like to ask the Minister what checks and balances are in place. On the one hand, there's the juggling of the intention to make sure that we have people paying their fair share of tax. So we want to make sure that the rules are fair and persistent and catch out those who would wish to do wrong. And on the other hand is the Balancing Act, where we don't put undue compliance burden on people who would want to trade and do business with New Zealand. And the question that is raised here, as in the previous part of the Act, is whether we've got that balance right. And that is all drawn into particularly sharp focus today, as we've just learned that the Prime Minister has some tax interests that we didn't know he had previously, or that he uses a vehicle, and I'm only just catching up on the detail of what was declared in his register of pecuniary interest, and so is he by the sound of it. His tax affairs seem to be more complicated than even he realises, and I'm sure we'll hear more to come on that. But over the recent days, and probably more pertinently, we've seen the Panama Papers come out, and they raise serious questions about New Zealand's integrity and the integrity of our tax system and our reputation more than anything else. We heard the Prime Minister, of course, say immediately that 24 million was raised. I'll come to the point, sir, which is about whether we have correct measures in place for ensuring, in clause 1, subclause 1C of section 71 in the bill, whether the tests in place are stringent enough and whether they are avoiding unnecessary duplication, or whether they are in fact too lax, because we are finding that New Zealand's reputation is under threat, and if New Zealand's laws are too lax, we risk having people come through New Zealand's system who are participating in money laundering and financing terrorism. And that is terrible for our reputation. We've heard in these Panama Papers that there are 60,000 instances where New Zealand's is mentioned. And this Act here... Sir?
I've ruled previously, asked the member to come back, focus on what the bill's about. You can mention those things in passing, but don't spend the whole speech on things which are outside the scope of the bill. Dr. David Clark.
Sir, I will bring it back, because the point of those references are to say, here in this Act, are we creating more loopholes? If people have complied with this Anti-Money Laundering and Counter-Financing of Terrorism Act 2009 requirements once, are they exempt forever? For how long are they exempt? If somebody has proven themselves in one jurisdiction or in New Zealand to have complied with the law in that respect, are they forever protected? If they've arranged their affairs in such a way that it's not detected on the first time through, are they protected forever? If the Prime Minister, to use a hypothetical, denies having any of this kind of involvement in one instance, and then it later transpires that he's arranged his affairs differently and he is captured by this, does that have an effect? Is that something that is protected by this Act? Does it have tests that can be applied again and again? Or are we saying here, and the Minister will, I'm sure, be able to direct us in 1C, that this is a once and for all test? Is this a test that applies forever into the future, or is this a test that is a once-off? Because I think that burden of proof is something we need to look at again, Mr. Chair.
Mr. Chair. Robertson.
Thank you. Thank you very much, Mr.